Hello, everybody. How are you doing? We do have a new document on Idaho 4 case, and it's pretty interesting. So, to get us all up to date for this document, we have to go back a couple real quick. So, December 22nd, there was a motion to seal. I need to switch these around. There was a motion to seal and then order to seal. The order to seal document, and then we had the order setting hearings on this document. Okay, these are the hearings that's coming up January 26th. So I don't need to read any of those, but this is the new one. If you look, it says it's January 12th. However, I think it just popped up on the case file sometime today, because I don't see any other videos or anything out there about this. I think it just popped up this evening. So I thought I should go ahead and put this out there and get you guys updated, because this is a pretty important one, and I find it really interesting. Like, what is Ann Taylor trying to say? She is definitely trying to send a message with this motion. I'm going to read it for you guys. Motion to unseal defendant's motion to reconsider orders, denying motions to dismiss the indictment, and in the alternative for permissions to appeal from interlocutory orders. Comes now Brian C. Kohberger, buying through his attorney Ann Taylor, public defender, and hereby moves the court for an order to unseal the defendant's motion to reconsider orders denying motions to dismiss indictment, and in the alternative for permission to appeal from interlocutory orders and a stay of proceedings filed with the court on 12/21/23, and the state's objection to this motion that was filed with court on January 5th, 2024. Okay, so they're like, yeah, somebody made a mistake here. And I'm going to read further what their explanation is. It says, this motion is made on the grounds that the pleadings and hearing thereon do not need to be sealed. Previous motions related to the grand jury proceedings were properly sealed pursuant to ICAR 32, Idaho Criminal Rule 6, and the court's order relating to grand jury proceedings. The pending proceedings, brought by motion and supported by pleadings, do not meet the language of the rule. The issues for the court to decide are procedural and legal and do not delve into areas covered by rule and order. Interesting. Mr. Kohberger sought sealing of his filings solely based on email communications with the Latah County Prosecutor's Office stating they wanted the filing sealed. The deadline for Mr. Kohberger's motion was imminent. Thus, in an abundance of caution, the defense filed a motion to seal. Counsel for Mr. Kohberger informed the Latah County Prosecutor's Office a motion to unseal was forthcoming. Mr. Kohberger moves the court to unseal the proceedings and filings on the basis that these filings and proceedings are not covered within ICAR 32. Mr. Kohberger acknowledges the right of the public to be fully informed of the issues. Mr. Kohberger has a right for the rule to apply as it is written, rather than disadvantage him with items remaining sealed that are not within the scope of ICAR 32. Okay. They're saying that they were basically told to seal them, but then they, I guess, went back and reviewed, and they don't feel that they fit within the rules of ICAR 32. So let's take a look at, real quick, this is the video that I did on December 29th. And I'm just going to, I'll link this below, but I'm going to read just this right down here, because a lot of people have been really confused as far as what an interlocutory appeal is. So I'm going to read just this portion. An interlocutory appeal is a motion asking the judge for permission to file an appeal now to a higher court within the trial instead of waiting until it's complete or conviction. If granted, it would put a stay on the trial until the higher court made a decision. They are rarely granted. It's also an interim decision and not final. Think of it as basically a temporary injunction. I see it as Ann Taylor doing her job and making sure everything is preserved for an appeal in the event of a conviction. So, I'm going to mute this real quick. I believe it was 11 a.m. and 1 p.m. Let me look. 11 a.m. Pacific time. That hearing is closed to the public. And the one at 1 p.m. is open. Let me get to the next page here. At 1 p.m., the court will hear argument pertaining to the order denying motion. Oh, let me go back and read 11 again. Yeah. So this is the same one. This is what they're talking about here. The motion that they filed. So they did this. So this is all we got to see. They want to unseal it so we get to actually see all of it. And I wonder why. I wonder what's going on with that. Why not just leave it sealed? Is she just playing, really smart attorney? Or is there something she thinks we really need to see? I don't know. Pretty interesting. Tell me what you think.
Hey all y'all. How y'all doing today? All y'all have a good day.